Well, good evening from a wet London. It's 10 p.m. here. I am David Green. I was formerly director of the Serious Fraud Office. I am now a consultant with Slaughter and May.
Brian, please.
Hi, I'm Brian Benchkowski. I'm currently a partner at the law firm of Kirkland & Ellis in the government investigations group there. And before returning to the firm in September of this year, I was for 2 years the Assistant Attorney General for the Criminal Division at the Justice Department.
Up next, please.
Hi, my name is Pat Linehan. I'm a partner in the Washington, D.C. office of Steptoe & Johnson. I'm in the Government Investigations White Collar Defense Group.
Thanks. Michael, please.
Hi, I'm Michael Diamant. I'm a partner in the Washington, D.C. office of Gibson, Dunn & Crutcher. I'm in the White Collar Group and focus on anti-corruption compliance and white collar enforcement.
Okay, so the idea tonight
Oh,
is
sorry.
that...
So we have Mark.
Oops,
Oh,
sorry.
yes. So no problem. My name is Matt
so
Jones.
sorry.
No problem, sir. My name is Matt Jones. I'm a partner Washington, D.C. office of Wilmer Hale, where I'm also in our investigations and criminal litigation group. I served during the Obama administration in the United States Attorney's Office in the District of Columbia.
Excellent, excellent. Now, forgive me cutting you off, but each panelist will give a brief presentation from now on with slides. And in due course, I will invite, provided there is time, any questions when after all is finished. So the first person to kick off is Brian.
Thank you, David. I'm going to talk a little bit about the Justice Department's recently published evaluation of corporate compliance document and talk a little bit about the background and history, the substance, the June 2020 update that occurred to that guidance document, and then talk a little bit about how that guidance has operated in practice. The document that was published in 2019 and updated in 2020 is an extensive guidance document that lays out for prosecutors the factors and other information that they will use to assess corporate compliance programs in the course of reaching corporate resolutions in the white collar space. It governs only attorneys in the criminal division, not attorneys in United States attorneys' offices, although it is often relied on for guidance in that way. And the history here is that previously in the criminal division, there's a tremendous amount of work done to develop a series of questions that prosecutors could begin to rely upon in order to assess the success or lack of success of corporate compliance programs. That work took place over a period of years. It was a great foundation for us to use. But one of the things that we thought we needed to do was to bring some structure and some additional detail to those questions and how they would be fleshed out when prosecutors considered them. And all of this is relevant because the foundational documents that govern prosecutors' behavior in this space, starting with the principles of federal prosecution of business organizations, which are found in the Justice Manual, and in particular, Justice Manual Provision 928.300 directs prosecutors to consider the adequacy and effectiveness of a corporation's compliance program at the time of the offense, as well as at the time of the charging decision when making decisions about how to structure corporate resolutions. In addition, the sentencing guidelines, the United States sentencing guidelines, which are discretionary for judges, but also are relied upon heavily by prosecutors in determining how to calculate the appropriate organizational criminal fine in a negotiated resolution, also direct prosecutors to consider whether the corporation had in place an effective compliance program at the time of the offense, and that depending upon how that question is answered, that can affect the amount of an appropriate fine in a criminal resolution. So the document that I'm going to go through is really, it's one of several that we did during my tenure in the department, and it was part of a broader focus on transparency in the white collar space, with the idea being that if the Justice Department and the Criminal Division were more transparent and more open about the factors and the thinking of prosecutors by giving prosecutors clear written guidance about how to think about these issues, that would benefit not only those prosecutors, but it would also benefit the defense bar, the corporate community, and it would lead to, in my view, more efficient and more effective discussions when the time came to work to resolve corporate matters. And so it is a lengthy document. I'm not going to be able to do more than summarize it, but it goes on for about 20 pages. It has been heavily dissected and looked at by compliance professionals, by external counsel, and hopefully also by the prosecutors who are charged with administering it. So the purpose of this document, and this purpose statement here is really my own, but it's drawn from various places in the document. The purpose of the document is to give prosecutors guidance and the specific factors that they should consider in evaluating a corporate compliance program when making decisions about the form of a resolution, DPA, NPA, declination versus guilty plea, the entire range of possible resolutions, how to think about monetary penalties, and also any future compliance obligations to impose as part of the resolution, including the very important question about whether or not to require a monitor or something less than a monitor as part of a corporate resolution. And the document is structured around three fundamental questions. One is the compliance program well designed? In other words, what does it look like on paper? What does the paper foundational documents, what do those documents tell you about the design of the program? Two, is it applied earnestly and in good faith? Namely, does it have support within the corporate structure, within the leadership of the company, not only at the top of the house, but also in middle management? And finally, does it work in practice? How is it resourced? And ultimately, what are the outputs here? How is the company actually applying its foundational documents and its program in practice? Some of the other concepts that are woven through this document include the fact that we at the department did not want prosecutors to believe or think that there was a rigid formula. If you go through this document, it is not a formulaic document designed to be a box checking exercise by prosecutors, because any assessment of the effectiveness of a corporate compliance program really should be done on an individualized basis and be an individualized assessment, because each company's risk profile is different, and how they're going to go about mitigating that risk is going to be different across companies, depending upon their size and their resources, across industries, and based on the level of scrutiny that they receive from the government. And we wanted to make sure that prosecutors understood that there's no single right way for companies to reduce and mitigate risk. In June of this year, we updated the document, and the reason for that was fairly straightforward, which is the document had been operating in practice for about a year. There were several corporate resolutions that had come down the tracks during the course of that time, and we wanted to get a better sense of how the document was being received, not only by prosecutors, but we also sought and received feedback from the business and compliance community. One of the things that we did as part of the broader effort in the department to enhance our prosecutors' ability to get better versed in compliance was we did a training session. We did a day-long session that has become an annualized process within the criminal division, where we invited in experienced prosecutors who had applied these principles in practice over time. But we also brought in members of the business community and the compliance community, and we sought their feedback over the course of the year, not only in our training seminar, but also informally, to get a sense of how the business and compliance community was reacting to the document. And then we made some changes to that document. None of those changes were meant to fundamentally alter the original document, but to put more meat on the bones, provide more granularity for prosecutors, and to continue the focus on continuous improvement, encouraging prosecutors to look at whether companies were continuously improving their compliance programs, and also to ensure that the prosecutors were focused on whether or not companies were receiving and analyzing data that they get in the course of managing their compliance program. So we made a little bit of a change to the second of the three questions, and we added one that said, is the program adequately resourced and empowered to function? And what that means is, as I said earlier, is our senior and middle management committed from the middle to the top of the company to the effective resourcing and application of the compliance program. And then we wanted prosecutors to take a look at autonomy and resources. Why did the company structure its compliance program the way it did? Is the company making further investment, not only in improving the program, but in training, development, and in testing the program? Also, we wanted to focus on whether a company is measuring the effectiveness of its program and it's learning from the data and the information that it's gathering in the course of that program. So we directed prosecutors as they assess these programs to look at those issues, including whether or not companies are conducting risk assessments and periodic reviews. What are they learning from those assessments and reviews? Do they provide easy access to their policies and procedures? And then do they track access to determine which ones employees are accessing so they get a sense of which ones employees think are important? Are they training their employees? And more importantly, are they tracking the outcome and the impact of their training? And finally, we wanted to focus on tip lines, on confidential reporting and investigations. Does the company test whether employees are aware of their hotline and they feel comfortable using it? And are they tracking the investigations that are surfaced by these hotlines from beginning to end? So those were the main focuses. There were a lot of smaller changes around the edges as well. But these were the two areas that I think were most important.
Brian, thank you very much indeed. Just going back over that, how would you summarize the drivers behind this additional transparency?
I think it was part of first of all, we had a great body of work, David, that had been done before I arrived in this area. And we felt like we didn't want that information in the formulation of literally 100 or so questions. We wanted to take that work that had been done and create something that would be useful for prosecutors to take off the shelf and review. In terms of transparency, obviously our focus was on prosecutors and making sure that they had guidance, because most federal prosecutors are not well versed in the operation of compliance programs. And so we wanted to create a document that would give them a foundational document that they could consult and that they could turn to as they were thinking through how to analyze objectively a compliance program. But we were mindful that when we published something like this, that the compliance community would take note of it. And we understood, I think, fairly that that companies, if they were being wise, would try to conform their compliance programs to the kinds of things that prosecutors were going to care about if and when the government came calling. And so the idea was to provide this guidance to prosecutors, knowing that it would be made public and relied upon elsewhere. And also, this is a fundamental part of the broader effort at the department to encourage companies to come forward, to use their compliance programs in a way that if they do discover misconduct, to come forward and disclose that misconduct with the understanding that they would be treated not within complete leniency as a guarantee, but that they would certainly be more likely to get a declination or a less stringent resolution if they were doing the kinds of things that are suggested in this document that prosecutors should examine if something did go wrong and a company found themselves sitting face to face with prosecutors at the Justice Department.
And in all that, obviously, the ultimate aim is better corporate compliance, yeah? Yes,
I think that it is clearly part of this is to encourage greater compliance for compliance sake. But at the same time, I wanted to demystify in that job. one of the things that always drove me crazy in private practice, and it wasn't just in this space, but it was in other spaces in the white collar area, that oftentimes you were left to guess how prosecutors were thinking about particular issues. There wasn't always that level of transparency. Mark Phillip, who I believe was on earlier, refers to this as the beginnings of trying to create almost a common law of white collar resolutions, where you have documents that are foundational documents. They don't create law, let's be clear, but they're documents that are going to allow the broader corporate community, the compliance community, outside lawyers to have a consistent understanding of how the department is going to think about these issues, which I also think leads to more efficient and effective outcomes, and hopefully over time more consistent outcomes across the range of cases that we deal with in the criminal division.
Okay, Brian, thank you very much indeed. We'll move on and come back to questions at the end. Patrick, the floor is yours.
Great. Thank you, David. And thank you, Brian. It's a great presentation. I think it's a good prelude into what I'm going to address, which is the new guidance, similar guidance that was issued by the Antitrust Division in 2 months after the original Criminal Division guidance was issued back. The antitrust guidance was issued in June of 2019, and it's quite similar and tries to serve the same purposes as the Criminal Division guidance, but it's unique. It's a unique change for the Antitrust Division because the Antitrust Division is a bit unique in one real respect, which is that it has what's called it has had for many years what's called a leniency program. And for those who are not antitrust specialists, although I don't necessarily claim to be an antitrust specialist, although I do a lot of antitrust work, the leniency program is a unique aspect of criminal antitrust enforcement. It was initiated in 1993, and I think, by the way, I think this is an important backdrop for the Antitrust Division issuance of criminal guidance. So I'm just going to spend a little bit of time on the leniency program. But under the program, the first co-conspirator in a price fixing or bid allocation or bid rigging conspiracy to confess to participation in that conspiracy receives leniency. If they're the first one in, they receive leniency. And what that means is that they will not be prosecuted. And typically, the individuals at their company will also receive similar leniency. There are two types of leniency under the program, Type A and Type B. Under Type A addresses a situation where a co-conspirator has come in and is giving the Antitrust Division information that it didn't have before, that is new to them, that can serve as the basis to open an investigation. Type B is a little different. Type B it offers leniency to companies that come in cases where the division may have information, but insufficient information to bring charges. Under both types, though, it is never leniency is never part of what's considered in determining leniency and qualifying for leniency of the program does not include the effectiveness of a pre-existing corporate compliance program. So to come out now over the last, like a year ago, and to issue this guidance was a big change in policy at the Antitrust Division. There was the sort of recurring mantra among Antitrust Division in the criminal section of the Antitrust Division prior to the guidance was the mere fact that the antitrust misconduct that occurred had gone undetected is proof positive that you don't have an effective corporate compliance program. So they would never. So anyone who is coming in or who is cooperating with the division really didn't have that argument in terms in terms of seeking a lesser sentence. That has all changed now with the guidance. And let me get into the guidance, and maybe we can switch to the next slide. So the guidance is actually structured quite similar to the criminal division guidance. And it recognizes that expressly. It's got a purpose, talks about it goes through the background as well as three overarching considerations and then factors and specific factors to be considered. Like I said, it went into effect in June of 2019. It is based on input that the division received from companies, from antitrust lawyers, and from the compliance community. We can go to the next slide. If you take a look at a comparison of the three overarching questions in the criminal division guidance and the antitrust division guidance, you can see that the three overarching questions are quite specific to the antitrust context. First, does the program address and prohibit criminal antitrust violations? Second, did the antitrust compliance program detect and facilitate prompt reporting of the violation in question? And third, to what extent was senior management involved in the violation? We can go to the next slide. Now, the guidance also provides 9 factors, more specific factors in the assessment of an effective corporate compliance program. I'll go through these quickly. I have stopping along the way for a couple because I think the guidance makes some interesting points on a few of these. And these will sound similar to the factors that Brian discussed in terms of an assessment of the effectiveness under the criminal division guidance. The first one, I'm sorry. The first factor is the design and comprehensiveness of the program. Question is this a real compliance program, or is it just a compliance program on paper? Does it have teeth? Is it periodically revisited and improved upon where appropriate? And interestingly, I think the antitrust division guidance actually talks about continuous improvement in ways that the original criminal division guidance didn't, and what went into the amendments or the modification of the criminal division guidance later, a year later. But like I said, continuous improvement, how well integrated is the compliance program into the business? And is there an accountable individual responsible for that integration? And guidance to employees on document destruction and obstruction of justice. Number 2, the culture of compliance within the company. What is the company's senior leadership doing to convey the importance of antitrust compliance? Number 3, responsibility for and resources dedicated to antitrust compliance. The fourth one is antitrust risk assessment techniques. In other words, is the program capable of assessing where the risk areas are and focusing compliance attention and resources on those risks? And here the antitrust division specifically references the use of new methods of electronic communication, presumably having in mind ethereal communications like WhatsApp. And while it does not expressly prohibit any particular new forms of these electronic communications, it does consider what the company is doing to manage the risks associated with those new means. You've also got training and communication to employees, monitoring and auditing. Here the guidance highlights the importance of unannounced audits and statistical testing and use of data analytics to monitor compliance. Number 7, are there reporting mechanisms? Are there controls and processes in place to ensure that the identification of noncompliance reaches the appropriate levels of management? Employee discipline and compliance incentives. This will be an especially salient consideration in the context of non-US companies, where either for cultural reasons or for differences in legal risk specific to that jurisdiction, companies may not be as comfortable or as as comfortable as in order to impose employee discipline as a U.S. company might. And lastly, remediation methods. Has the company repaired its compliance function where it has failed to detect misconduct? So in determining how a non-leniency co-conspirator, keep in mind a leniency applicant will already in effect receive immunity. So this guidance doesn't really benefit leniency applicants, but to the non-leniency co-conspirator, how such a co-conspirator is charged or what sentence the division will recommend, they'll be looking at closely at these factors. And these factors are not, they serve really two purposes. And I think this echoes what Brian had said earlier. It does provide a framework for companies to develop and strengthen their own internal compliance programs, but it also does provide a roadmap for defense attorneys like me who are trying to make arguments that favor a more a less stringent settlement or a stringent plea or fine. So we have a very structured way of approaching trying to persuade the prosecutors to be lenient on a non-lenient client. These 9 factors are you could just hand them off to your associate and they can organize their slide set appropriately. If we can go to the next slide. A couple of other key takeaways from the guidance. And when the guidance was announced, Makin Delrahim, who is the head of the antitrust division, also announced that the antitrust division would consider using, for the first time, deferred prosecution agreements or DPAs. This was another big change for the antitrust division. Previously relied solely on the leniency program for any agreements not to prosecute, or at least to defer prosecution. A couple of notes here. Delrahim made clear that the division's consideration of DPAs will not lead to any, or at least does not include any consideration for NPAs. NPAs are strictly restricted, or the equivalent of NPAs are strictly restricted to the leniency applicants, and would provide an odd incentive system to offer NPAs to companies other than those who were the first in and qualified for leniency. And in terms of practice, obviously the guidance has been in effect for a year. We've seen some DPAs in the antitrust side, but we've only seen them in the healthcare context. And the reason for that is that you've got and it becomes relevant in particularly in the generic drug price fixing investigation that's ongoing right now. But it does allow companies to plead guilty without triggering what's called Medicare Medicaid exclusion. Whereby when participants or people who benefit from payments through the federal healthcare system have been convicted of a crime, they are typically excluded from participation in those programs. Finally, the guidance not only applies to the consideration of charging decisions, but also in consideration for recommended sentencing. Previously, the division had not recommended credit for defendants pre-existing compliance programs. However, that will now change. For purposes of companies that and the convictions usually come via pleas in the antitrust context. Usually, defendants are typically dead to rights on this. Very few companies actually go to trial. It's not to say that it's not to say that there are some that actually have done, and there were a couple in the auto parts investigation. But when it comes to the sentencing phase, there will be an assessment by the prosecutors as to the effectiveness of the company's pre-existing compliance programs, and that will affect the way in which prosecutors recommend sentencing and fines. and the extent and whether probation is warranted. There is no sentence. There will be no sentence reduction, no recommended sentence reduction under the guidance where there's unreasonable delay in reporting the illegal activity of the government. And there's a rebuttable presumption that a compliance program is not effective when high-level personnel employees with substantial authority participated in, condoned, or willfully ignored the offense. So that's the antitrust division guidance. Like I said, a lot of the same drivers that are behind the criminal division guidance, still relatively new. And we are interested. It'll be interesting to see what questions arise. There's one more slide. I don't want to overstep my time, but there are a couple of open questions which I can run through very quickly. As we discussed, interoperation with the leniency program, the applicability of guidance to individuals with compliance-related responsibilities. Unclear how that will work. Impact of companies improving their compliance programs where the improvement was initiated prior to the offense, but continued and developed afterwards. There's an aspect, there are cases in which antitrust offenses and non-antitrust offenses are brought in the same case. Which guidance or whether both guidances apply and how to reconcile that, that certainly will become an issue. I think with that, I think I'm getting close to my time, so I will end my remarks there.
Patrick, thank you very much, and congratulations on the haircut, if I may say so.
Thank you.
Just
or lack
one kind of general question. How effective do you think this program has been?
Do you mean the under the new guidance or the leniency program?
Yes, the new guidance. Yeah.
Yeah. So I mean, I think that this antitrust defense lawyers have been waiting for the moment in which a pre-existing corporate compliance program can matter. That has not been the case prior to the guidance. So. So if you were not, if you were not the leniency applicant in any given investigation, you were handicapped. Now we have something to work with, and you also, I mean, so like I said, the two purposes or the two ways I think the guidance is helpful is not only for purposes of arming you with arguments that you can use on behalf of your client, but you can also go back to your clients who may not foresee the day when there's a dawn raid or a grand jury subpoena and say, Department of Justice has now defined what they look for in terms of an effective antitrust compliance program. It would be wise for you to look at it and to and to put it into operation.
Okay, Patrick, thank you so much. Matthew, now, provided you have forgiven me for my lack of introducing you earlier, the floor is yours.
And so I just wanted to follow up with a couple questions for Brian and Patrick on the work that they've presented. So Brian, first of all, I noticed that you emphasized this key element from the revised guidance about the adequate resourcing of the compliance program. And it seems to me that's among the most objective of the measures of the evaluation guidelines. It's just basic numeric questions like staffing or budgets. I think this question is really top of mind for a lot of our clients these days, particularly Japanese companies, because of the upheaval in the global economy as a result of the pandemic that's causing many companies to look for places that they can reduce spending, reduce headcount. And so I have many clients who are asking, as they are laying off employees, as they are furloughing employees, asking whether they can or should make cuts to their compliance programs similar to those that they're making in the revenue generating parts of the business. And you of course try to advise them to avoid a short-term perspective that could lead to significant harms down the road, and but also to look to see if there are areas in which business restructuring is actually reducing risk in some way, such that you could justify reduction of your compliance spend. But these aren't easy decisions. So I'm interested in your thoughts, Brian, on how your former colleagues will react to companies that are cutting their compliance budgets now in response to these economic headwinds.
It's a great question, Matt, and thank you for it. It certainly came up while I was still at the department, and I can tell you how we thought about it then. Obviously, can't hold me to what the department's going to do in the future, but I would say that between this issue and questions about analysis around a company's ability to pay a particular corporate fine, that those were two areas that we thought a lot about as we moved into the pandemic and in thinking about how companies should respond. And I think much like the rest of the evaluation that we ask prosecutors to do as part of this guidance, it really does need to be an individualized assessment of the company's decisions. I think that every reasonable person would understand that as a company is downsizing, shrinking in the face of the economic realities associated with the pandemic, that to tell them they have to maintain, a compliance workforce of a certain size and continue to resource their compliance program in a certain way when every other part of the business is shrinking, and as you aptly described, may actually be de-risking, at least in the short run. It would not be wise for the department. I don't think it would be fair for the department to insist on a continued resourcing as it had been prior to the pandemic. That said, I've also, we've told people, and I've heard it said by other senior leaders at the department, if you just completely shut down your compliance program, fire all of your compliance personnel, that isn't going to be looked upon favorably if there is a problem in the business as it continues to operate during the pandemic. So I think that companies need to be reasonable. They need to be able to make decisions. They have to be able to be flexible, and the department shouldn't unfairly hold them to reasonable decisions that they made. How that reasonableness will be assessed will be a function of the size of the company, the economic reality facing that company during the pandemic. Because, if you look at, there's certain industries and businesses that have just been devastated by this across the board, and there are others that are continuing to be able to operate at some level, and others that are doing okay, right? And so I think that whatever that economic reality is going to need to dovetail with how companies treat their compliance resources. And if they do it in a way that's consistent with the overall economic reality in the company, then I think they'll be treated fairly by the department.
Okay, thank you. Matthew Dasuke, I think we should move on to your presentation.
Okay, so Michael and I prepared next one. So, but before that, so if you allow me, so I'm interested in the UK compliance guidance, so which well, and so do you have any comments or so based on your perspective? So you can compare two different guidance to address same issue. So from UK perspective, so if you allow me, so can I ask your comments on that point?
Sorry, you're asking me, yeah?
Yeah.
Yeah, okay. In my time, remember that I left the SFO in April of 2018, and by that time we had what, 4 DPAs. Frankly, prosecutors were grappling with that and trying to get it right, and so was the judiciary. And over time, things has changed, and now the judiciary and the SFO, I think, are far more confident in dealing with DPAs. So I think over time, you will see that confidence, come to the fore, and you'll see more DPAs in the UK.
That's great. Okay, so in terms of the evaluation of corporate compliance program, so yeah, so there are three fundamental questions described in the DOJ guidance. So, but in UK, so what kind of points and factors are very important? So in UK.
I think, again, I think the UK is very much on a learning curve here, but I think the obvious lessons are that you want to see not a huge, expensive, well-lawyered compliance policy, but a simple, straightforward one, which is well-known to all employees, accessible to them, which is backed up by training and lived by senior management. Those are the basic, obvious things you want to see. But I wouldn't pretend that the UK is on anything other than the beginning of a learning curve about this. And my time, certainly at the SFO, I always said, for reasons which may be obvious, that we were not funded to provide guidance on this kind of thing. It was for the professionals to interpret the law and give guidance to their clients. Now, I said that for many obvious reasons, but I think it's much to the credit of my successor that she has now, with the benefit of a few DPAs under her belt, she's now able to be, I think, much more accessible and transparent in terms of what the SFO expects. And I congratulate her for that development.
Thank you so much. So yeah, so I would like to make so very short comment on that. So because in Japan, so there's a discussion whether or not we need to have a DPA-like system in Japan, and so because of the digitalization and the internationalization, and it's hard for government to collect information so regarding their conduct. So, and in order to encourage the companies to cooperate with their investigation or prepare for the prevention system. So DPA type pre-trial agreement or so the guidance which make it clear for the company to prepare for the good compliance program are a kind of good aspect and the transparency. So as mentioned, Brian said, so it's really important to make incentive work better. So, and in that aspect, so we have a lot of things to learn from not only US, but also UK. So that's why, so I made comment and asking question to you. Thank you.
I think at base, this is all about what is the policy objective. I think the policy objective surely is a better corporate culture, a compliance culture. And I think the real challenge is to show and prove independently that better corporate culture means better profitability and better business. That's the real challenge. But that's a long way in the future and probably not something for lawyers who represent companies.
Yeah, you got a very good point. Thank you. Yeah, I think, Michael, so it's your turn. Yeah, please.
Great. Thank you. Thanks everybody for that, for those great presentations. We're going to talk a little bit now about whistleblowing and internal reporting mechanisms. You heard both Brian and Patrick talk about how important those are for purposes of the compliance guidance issued by the antitrust and the criminal divisions, respectively. I'm going to start this off, though, by talking about a different enforcement agency, which is the U.S. Securities and Exchange Commission. And specifically, we've now, in the United States, had a decade of living with a whistleblower bounty program that was put into effect by the Dodd-Frank law of 2010. And while I'm going to slide into discussing best practices and lessons learned around internal whistleblowing systems, and then Daisuke and I are going to talk a little bit about whistleblowing in the Japanese context. Of course, my presentation's more U.S.-centric. I wanted to open up with a discussion of Dodd-Frank whistleblowing, because it really hangs over the decision-making of corporations around whistleblowing, corporations that are subject to U.S. securities laws and subject to the bounty program. And look, that's for obvious reasons, right? To have a program where significant financial rewards can attach to whistleblowing makes it more likely, I think, obviously, that whistleblowers are going to go outside of the corporation and provide information to the government. And in this case, the SEC provides this percentage of recovery, which doesn't have to be entirely or solely collected by the SEC, but could also be collected by other parts of the U.S. government. It provides a percentage of it to whistleblowers who present credible, original information that lead to an effective, successful enforcement action. And these awards have become very, very large. They can range from 10 to 30% of the money collected. Although the SEC has recently provided some new rulemaking that gives it even greater discretion in how it awards the awards. But this year we've seen the two largest single awards issued to individual whistleblowers, $114 million and $50 million. So you can imagine that prospective whistleblowers and the lawyers who represent them in these cases recognize that there's real money to be made here, and that, I think, colors and the way corporations have to treat whistleblowers, how they have to think about these issues because of this risk. And we're talking somewhere in the neighborhood of 5,000 tips per year that are going to the Office of the Whistleblower. So what does this mean for the purposes of compliance program and the reporting element of it? Somewhere in the neighborhood of 85% of company employees who successfully report information under the whistleblowing program, under the Dodd-Frank program, had already raised their concern internally. And that is, I think, a stunning statistic. It is in keeping with statistics that you will see for the False Claims Act key TAM provision. And in fact, when Dodd-Frank was being rolled out a decade ago, my colleagues and I took a careful look at key TAM relators because we thought, well, this could be a very similar concept of at times an employee, it doesn't have to be, but it could be an employee blowing the whistle on his or her own organization, and found similarly a very, very high percentage of those started out as internal reporters. So this is consistent in a number of different areas, and it underscores the importance of how you handle internal whistleblowing. It is obviously crucial control. It's a control for publicly traded companies that's mandated by Sarbanes-Oxley, and there are other guidance and regulatory regimes that require it. And it's important that you catch misconduct, right? It's just a bottom line important tool. But in addition to all that, it could head off serious problems for the corporation. And that's the first point here, which is to take the employee complaints seriously. Neglecting those complaints can lead to external whistleblowers, in addition to frustrating attempts to prevent ongoing misconduct. One call out here on this concept, which is that sometimes complaints from whistleblowers are vague. Sometimes, frankly, often, whistleblowers are disgruntled. They've gotten poor performance evaluations. They may be designated to be separated from the company as part of force reductions, especially in this period of the pandemic. and companies are laying off, are restructuring. Being very mindful that's important. And just because the complaint is vague, just because someone is disgruntled, does not mean that he or she is not telling the truth. And frankly, even if a part of what the whistleblower is saying is untrue, perhaps with regard to his or her personal performance, that doesn't mean that there isn't a kernel of truth in what they're saying about the issue that's been brought to the company's attention. And so that's part of being responsive and taking these complaints seriously. The next point, and this is maybe a somewhat obvious one, but I find that it pops up time and again with clients, was ensuring that your reporting mechanisms are operational. Are they going to the right person? If somebody calls the hotline, whom do they speak with? Are the links working on the online program? Again, especially with people going remote, I think it is a fair assumption that whistleblower reports are more likely to be using those channels, and so checking them and making sure they're working is important. It's not that hard to do, and doing it periodically can save you a real mess down the road if you've ensured that they're functioning. Next point is about your investigation protocols, and here too, I think it's again because we're dealing with this pandemic. More challenging. Doing investigations remotely, which is increasingly happening, is more challenging. But I can't stress enough how important it is to move on information in a timely fashion, scope the investigation, and reach a conclusion in a reasonably reasonable time frame. You don't want to let these issues linger. It increases the likelihood that the employee becomes an external whistleblower. And it frankly increases the chance that this could spiral out of hand before the company can remediate whatever issue has been reported. Also very important to focus on anti-retaliation. The Dodd-Frank itself contains protections for whistleblowers. There are a slew of other laws, regulations, and guidance around retaliation against good faith whistleblowers. This is, I think, clear, but it can become particularly tricky again in the context of a poor performing employee or an employee who is within a group that is scheduled for restructuring or reduction in force. I urge clients to tread very carefully in those situations. Even if you really want to terminate an employee, if that employee has provided credible, good faith information about potential misconduct, it doesn't mean you can never terminate that employee, but typically you want to hit pause in those situations and look very carefully at what's going on and ensure that the separation is for good and valid reasons, and really, frankly, to give yourself a chance to examine the information provided by the whistleblower and speak with him or her further before that person leaves the company. Next point is around documentation and ensuring documents are retained and preserved. Here too, I think this is challenging in the context of the pandemic. When folks are working from home, you have employees operating from home offices, creating their own records, potentially using devices that are not company issued. All of that needs to be subject to appropriate document retention policies from the organization. And if you do launch an investigation, make sure that you're implementing appropriate protocols such that those materials are, again, preserved in an appropriate way and can be used as part of the investigation. That extends to if you need to